Commission for the Codification of the System of Judiciary and Public Prosecution in Poland. And I think the public prosecution is the main part of her expertise. So Karolina Kremens, and she's also an ice hockey player, and it's something that I really appreciate, and I'm just, well, I'm lost for words. So Karolina Kremens.
Thank you so much. Are you happy with the yesterday's result of the hockey game? I'm so sorry. I'm so sorry.
I'm not.
First of all, thank you very much, Jarosław, for inviting me to this conference. I'm pleased to be here. I'm very happy that the coincidence of events in my life happened, that I can speak on this conference and that I can speak on one of my favorite topics in the world, which is the prosecution. As I revealed earlier, I used to be as assistant or associate prosecutor for 4 years of my life. So I was working in a small, maybe not that small, but in one of the offices of public prosecution service in my hometown, Wrocław. Some of you may know the city by Breslau, which used to be the old German city. So this experience, of course, formed my my life, formed my future research choices. And after I left the office and I started working at the Department of Criminal Procedure at the University of Wrocław, Faculty of Law, Administration and Economics, I focus in my research on the role and position of the prosecutor, on the organization of the prosecution office, on the amount of cases that prosecutors got in their daily schedule, and how the system was working, both from Polish but also from the comparative perspective. I was fortunate enough to work with the Ministry of Justice at that time. It was 2009, as I revealed. I'm sorry, 2012, when I left the office, and working with the Ministry of Justice allowed me to write 2 reports regarding the structure of prosecution service in Poland in 2 different aspects. And then finally, I ended up writing the book that, from comparative perspective, was discussing the role of the prosecutor in criminal investigation in 4 different countries, and trying to figure out what kind of role the prosecutor should have in this crucial, as I believe, stage of the criminal process, and becoming more and more crucial nowadays. I will speak about this a little bit longer, a little bit later, but what I would like also to say that, yes, this is true that yesterday I became a part of the commission, and therefore whatever I will be saying I will be saying in my official capacity as the professor of the University of Wrocław, and not as the member of the commission, because I will be also speaking about the topics that we will be probably soon discussing also on the commission. So this is not the view of the commission, this is the view of me, Karolina Kremens. And right now I work for several years not as a member of the Department of Criminal Procedure. I'm the director of the Digital Justice Center. Right now we focus in our research on the impact of new technologies and on criminal justice systems in different ways, artificial intelligence a little bit, but also on the digitalization of everything that is going on in criminal justice systems, the virtual justice, also in the context of the International Criminal Court and International Criminal Procedure. So comparative law, European law, international law is also in my scope of interest. But going back to the topic of my presentation, which is the independence of the prosecutors, I believe that before I start discussing this with you, because I really do hope it will be a discussion, not a boring lecture that I'm used to give from time to time. And I do apologize that I don't have a presentation, and I decided yesterday, I promised that I will not have one. And I'm super happy that I did decide not to prepare a presentation, because after, and this is, I'm not trying to be nice, but this would be really difficult to have a better presentation than we got a moment ago, and it wouldn't be something that I could have prepared during the night. So I'm happy that I did make the right choice, and congratulations on all your cases and all your nice slides that I really adored, Jakub. So the first thing that I think we must take into account when discussing the independence of the prosecutor is the position that right now the prosecutor has in many countries, most of the countries, which is not only limited to this traditional way of thinking of the word what prosecution is. So this traditional way of thinking what the prosecutor is doing is prosecuting, meaning bringing charges to the court and prosecuting the case, accusing someone of committing a crime and prosecuting the case, trying to prove in the court based on evidence that the person is guilty. This is this traditional role of the prosecutor. Currently, we are for many years now expanding the role of the prosecutor to other areas, not only to mention some civil actions that the prosecutor can take in some countries, administrative actions. We talked today with our colleague from Spain about also fundamental rights that the prosecutor can engage with, but mostly the prosecutor in many countries is focusing on the investigative actions. And Poland might be a great example of that. I mentioned before that Polish prosecutors must attend the crime scene. So we are kind of a super investigators and we are assisting, or well, it is phrased that we are active as the investigators and police assist us. But the truth is, the practical truth is that we are just assisting the police in all those actions. But also in countries that traditionally would claim that the prosecutor is not there to investigate, let's take US as an example or UK as an example, put the prosecution as the main task for the prosecutor. This is true that prosecutors very often engage in investigative actions, especially when they have to derive the evidence from somewhere when the police is not doing this properly, or sometimes informally talking to witnesses before the trial or during pre-trial stage. So investigative actions of the prosecutors in many countries is a fact based on the law, but in those where the law does not give a formal leeway for the prosecutors to engage in investigation, they still do this. So being a super investigator or special investigator is in many cases a power of the prosecutor as well. So not only prosecution, also investigation. And now we move to the adjudication. So the prosecutor is right now by many treated as a judge by another name. As we take into account the fact that prosecutors in many countries may impose charges, not only charges, but also may impose some kind of decisions that are similar to what judges might be doing. So sometimes fines also, but also in exchange of some form of accepting the guilt, some forms of little penalties, but also are very, very active in negotiations. And those are those different ways of finding the result of the trial, of the criminal case out of the trial, that prosecutors are very active in. So we kind of, as international society even, are expanding the role of the prosecutor during criminal process, engaging them very early in the criminal investigation, asking them to prosecute, but sometimes also giving them a lot of power in deciding whether the charges will hit the court, or maybe in negotiations we will exchange this into something else, and not always the judge will be the one, or the court will be the entity to confirm it. Sometimes some countries do not allow for that. So seeing the prosecutor from this perspective, we must start thinking why we would like the prosecutor to be independent, in what capacity the prosecutor must be independent, and is it the same independency that the judges are having if we are expanding those powers of the prosecutor also to this other area that is not traditionally recognized as the area where the prosecutor is prosecuting or investigating. And of course, we can talk about independence of the prosecutor from two perspectives. One perspective is, let's call it external or vertical. This is the perspective where we're thinking that the prosecutor service or public prosecution service is in relation with different powers that are existing in the country. And especially this is usually mentioned as the executive power and judicial power. So the prosecutor is in between, and I will talk about this in a moment. But there is this other form of independence, which is crucial to understand the horizontal. Vertical will be right now. So internal vertical independence, when when we are talking about the independence of the prosecutors within their own prosecution office, and in systems when there is a hierarchical form of prosecution offices, this is the dependence of the prosecutor from one lower office towards other offices that are, or prosecutors from offices that are above. So internal independence, which is vertical, and external dependence, which is horizontal. And of course, we can engage here in a long discussion that academics love to take a part in, whether there are certain models where the prosecution is associated with executive power or judicial power. I did my research some time ago on how conclusive those associations of the prosecutions in European Union countries are with one or the other, and this is not conclusive. Like, there are some scholars and some prosecutors who believe that certain countries belong to the executive power and those other countries belong to judiciary power. But some other scholars and some other prosecutors would say, but wait a minute, there are some elements of the system that make it hard to believe that this particular country belongs to the executive system. We should think about this country more as judiciary. And the question is how we decide whether the prosecution service is more on the side of executive power or more on the judicial power. The most typical way of thinking about this, and this is crucial right now when we discuss the situation of Poland, is whether the prosecutor general is associated with the Ministry of Justice. And many people would say, also those who are prosecutors, but also outside of the legal sphere, that this is the crucial element of whether the prosecution is bound with the executive system or not. This is untrue. Just to deconstruct this way of thinking about the prosecution system. Not only the close association of the prosecutor general with, or attorney general, as sometimes the person is called, with the prosecution, with the Ministry of Justice, is making the prosecution service a part of the executive power. There are certainly systems where the association exists, but there is no real dependence on the executive, and only some kind of general forms of guidance from the Ministry of Justice are given to the prosecution service from the executive. And we should take into account not only who is choosing the Minister of Justice, the Prosecutor General being Minister of Justice, but we should take also into account what other elements of the model we are thinking. So this is not only, as I said, how we choose the Prosecutor General, but this is also what are the relations within the Ministry of Justice, whether Minister of Justice, the Attorney General, can give direct instructions to the certain prosecutors deciding on the cases, how this the budget is being constructed, and also, which is very often overlooked, what are the competencies of the powers of the prosecutor during criminal investigation, whether this is just prosecuting a case, or maybe this is also investigating a case very closely with the police. Because as we all know, police is always associated with the executive. So if the relationship between the prosecutor and the police during every single simple case, but also in a bigger perspective, is very close, and sometimes in some countries prosecutor can even give orders to the prosecutors which must be obeyed, if not disciplinary proceedings are imposed. So this makes the prosecution service more bound with the executive. But simple association of the Attorney General with the Ministry of Justice, which is a case right now in Poland, is not making the prosecution service totally dependable on the executive, and it should be clearly acknowledged. Just for the Polish lawyers, perhaps, who are sitting here, we can also make the let's say, theoretical exercise in our heads. Just before October 15th, we had the Prosecutor General who was Minister of Justice at the same time, and it didn't change up to date. We still can say that before, perhaps, December 13th, rather, the dependence of the prosecution service of Poland on the Minister of Justice was much deeper than it is right now. And the law did not change. This is the personality, perhaps, of the Minister of Justice and the way how he is serving his capacity as the Prosecutor General that determines this. So something that we do not very often take into account because we love normative forms and we like how it is framed in the law, that this is not always how the law is constructed, but this is also the legal culture, and this is the personality of the person that is holding the office that determines whether certain powers are used or not. The leadership, but also I think on the lower levels. This is also very well seen when I was discussing those cases several years ago with Dutch prosecutors and Belgian prosecutors, and I was complaining. Remember, this was like 2020. Bad things are happening in Poland. Prosecutors are making charges because they are told so and so on. And I'm complaining about those regulations that we have in Polish system, that the prosecutor can be told what should be done in a particular case by the prosecutor general or by someone from the higher office is told by the prosecutor general, and then the order is like just going down on steps, and still the person on the bottom has to follow this. And I was complaining also about the ability to take over the case from the prosecutor that does not cope with the orders of the prosecutor general given, let's say, in a very informal way, or moving a person from one office to the other as a form of a punishment. And those Belgian and Dutch prosecutors surprised me because they said, well, in our law, we have similar regulations. And I remember one discussion with German prosecutors also that they were surprised that they even have those regulations in their law because they are never used. So this is not the fact that we have the regulation which says something and makes the prosecutors dependable on the Minister of Justice and those who are given orders by him and push them further. But this is very often around that. And just out of the scope here, but it also is a good example. While we are having a good conversation right now or debate in Poland about how dangerous Pegasus is and how we should not use it and how it should be, it is horrific that it is being used by the secret services of different kinds and police and prosecutors and overused. At the same time, in Western Europe, there is a discussion how useful it is to fight terrorism, maybe not on the example of Pegasus, but in other contexts about other cases and EncroChat and other forms of I would say secret surveillance that we didn't know some time ago is used in a good cause. So my claim, again, on another conference that I was attending, that we should ban Pegasuses or those types of secret surveillance was confronted with this other perspective that, but those are useful tools if you use them properly. So this also gives us a different perspectives on how association of Minister of Justice with the Prosecutor General should be constructed. And of course, in Polish context, and again, I will say it in my own capacity, but I think that we in Poland all agree at this point on this, that those two offices should be immediately detached from each other, but I would say, add to this, that rather from symbolic reasons than from actual reasons. And I used to claim that this is not necessary to maintain the independence of the prosecutors if all around normative if the normative environment around and the legal culture around is properly constructed. One of the most, unfortunately in Polish, amazing articles on the international standards concerning public prosecution service, again written in Polish by excellent Polish prosecutor Małgorzata Szeroczyńska, she invoked in this article that there is nothing in the international regulations that forces to detach the prosecutor general from the Ministry of Justice. And actually, there is nothing in the international standards, also guidelines that Jakub was telling us about today, nothing that says that prosecution should be detached from the executive power. It just gives the standards that have to be met, and especially on the level of transparency, even in the situation when there are some orders that are given from the executive to the public prosecution service. Because everybody are aware that prosecution, to some extent, will be always in a connection with the executive. So how this interaction between public prosecution service and executive with the government is being done, it is important. Of course, there are countries that will be always claiming, or maybe at least right now they are claiming, that public prosecution service should be bound together with the judiciary. An excellent example of this is Italy. For those of you who don't know it, but in 1988 Italians changed their legal system from our traditional inquisitorial system with the judge who is intervening during criminal proceedings into more Anglo-Saxon driven, something that we had in Poland from 2015 until 2016, but it works for 30 years now. And after those 30 years, they are saying that, well, it's actually working right now if we raised another generation of lawyers who doesn't know how the law looked like before. So only if we train people in a new system, the system is working. So maybe it gives some hope also for additional changes in Polish system. But moving this aside, Italians are claiming all the time that this is the judiciary, the prosecution should be connected to the judiciary. But again, is it coming from normative reasons? Rather not. It's coming from the historical perspective and from the awful experience of the Second World War and combination of the executive with the public prosecution service that during the fascist regime at that time. So the strong detachment from the executive in Italian system is driven rather by some historical accidents. And right now, this is just a habit that they put it into the constitution. So they are used to the fact that prosecution service is combined with judiciary. And even there is a big discussion all the time whether some competencies that public prosecution service is having in Italy can be done by public prosecutors and not by judges. Recently, there was this very interesting judgment by the European Court of Human Rights in case Brazzi versus Italy, where the court said, well, that the prosecutors in Italy, even if they're a part of so-called magistratura, which is kind of a criminal justice or justice system, as we could call it in Italy, they are not equal to judges, and there must be some differences between those two. So even from this perspective, even if they are within one system, within one group and closely associated with judiciary and can go back and forth within both offices, and they can simply go from being a public prosecutor to the judges, and this is not very difficult for them. They are still not perceived as independent enough from I don't know what, but independent enough to make all the decisions that we would grant judges with. So the independence, it shows us that the independence that judges have is a different independence that the prosecution might have. And as I said before, there is no conclusive I would say, model that we can say that Germans are executive only and Italians are totally combined with judiciary. And very often there are some arguments showing that those relationships in between public prosecution service and judiciary, and public prosecution service and executive are losing up, and there are some signs that maybe this prosecution is in the middle. Maybe this isn't, some writers claim that prosecution, even though we have the separation of powers, parliament, executive and judiciary, maybe prosecution is somewhere in between, not to mention that sometimes the Attorney General is being appointed by the parliament, and sometimes the Prosecutor General, even if not being a Minister of Justice, is appointed by the President. We also know such systems. So is it the only way how we should perceive the independence of the prosecutor? So in between the executive and judiciary? Probably not. Even more important is when we start thinking about the prosecution service and the simple prosecutors when they are working within the office and how dependent they are on their own supervisors and supervisors from other offices that are above the prosecution service. So, do we really believe that every single prosecutor that makes the decision during criminal investigation, and this is my question to you, during criminal investigation and during criminal prosecution, whether every single prosecutor should make every single decision during investigation and prosecution totally independently, and no one, including the boss of the office where the person works, should have nothing to say about the charges that are being laid, the penalties that the prosecutor proposes, and the behavior during the trial and type of evidence that is being presented. Is there anything that we could accept as prosecutors, as a society, as judges, as lawyers, that would be limiting the independence of the prosecutor? And of course, we can say that the prosecutor should be ultimately independent. There should be nothing that limits the prosecutor, but somehow we feel that okay, prosecutor is important, but this is not a judge. There's always a judge that would be above the prosecutor and making decisions, confirming decisions of the prosecutor, and the ultimate choice will be on the judge. Maybe we can accept the fact that since there is a judge who will be eventually, or the court that will be eventually evaluating what the prosecutor is doing, is enough. But we should also remember that there are some decisions that in some systems that are not overlooked by judges, or not always overlooked by judges. Let's say discontinuation of the criminal investigation if no one appeals this decision, or in systems where there is not even a way to appeal this decision whatsoever. So in such case, the court will never evaluate the final decision of the prosecutor not to investigate the case further or not to prosecute. And there are some systems that have very interesting choices for how to limit the powers of the prosecutor and independence of the prosecutor. This is going farther than European Union, but I think that this example is not only interesting, but also very current when we are reading newspapers right now. That's why I decided to invoke it. This is concerning something that is called a grand jury. A grand jury, this is an old English common law institution that was abandoned long time ago, but by English system, and all other countries that were colonized by England. So let's say Australia, South Africa, Canada, India, and so on. But only in US, in certain states, and most of all in federal system, remained as a tool for limiting the independence of the prosecutor. It is phrased in a way that when the prosecutor wants to bring charges to the court, again, in federal system always, for some certain rights, and in some states it still exists, when the prosecutor wants to bring charges against the person, but charges not understood as we understand it in Polish language, but charges in form of the indictment, form of accusation that is moving the case forward to the court, the prosecutor cannot do this independently because the Constitution of the United States forces the prosecutor to bring the case first before the grand jury. And grand jury, this is just a very big jury. It's not the same jury that we see in most of the cases in TV series on Netflix that sits there and decides on the guilt of a person. But this is the grand jury, which is actually nominated for a longer period of time, not only for one particular case. This is usually from 16 to 23 people. And they, in total secrecy, in privacy, decide whether the prosecutor is allowed to bring charges against the person to the court. So this is just a form of checks and balances on the prosecutor, whether the prosecutor that does not extend his or her capacity to accuse someone of a crime before the court, and giving a simple people, peers of that person, because the grand jury is chosen from the same group of people as a regular jury. So those are not lawyers; those are simple people from the same area that the person, from the area where a person is charged in, and they must decide in secrecy with the by being presented the evidence by the prosecutor, whether the case will reach the court. So this is kind of checks and balances on the prosecutor. What is super interesting is that we don't know what is happening there in the secret room where this grand jury is deciding, that the prosecutor can not only present whatever he or she wants, but also that the prosecutor can ask a grand jury, and grand jury has a power to summon people to come over and testify, and none of the precious rights of the defendant apply during those interrogations. So there is a big discussion what kind of powers the grand jury has and how far does it extend to the rights of the accused that we would normally have in a criminal trial. What is more interesting even is that all of the cases that by federal courts, criminal courts in US right now are being discussed, in case of Donald Trump, they have to go through the grand jury. So this is super interesting to know that this is not actually the prosecutor that makes the decision that the case will hit the trial, but this is actually the grand jury made of 16 to 23 people that is making this decision, and those are pure, simple citizens, and this is their power to decide. Of course, the downside of this process is that it's very rare that the grand jury makes the decision different than the prosecutor wants. It is confirmed, and there is a very nice line saying that if the prosecutor decides to accuse the hamburger, or in some cases they say the sandwich with ham sandwich. If the prosecutor decides to accuse the ham sandwich or hamburger, grand jury would grant it. So very often, in 99% of cases, if the prosecutor wants the case to hit the court, the grand jury would agree. The 1% or even less than 1% of cases is when the prosecutor really does not want the case to hit the trial, but uses grand jury as a form of shield for himself or herself. I will have to I don't have to bring it to grand jury, but if I don't bring it, my voters or people who who have something to say about me will not be happy with me not moving the case further. So I will put it in front of grand jury, and grand jury will decide as I want. So this example, of course, does not exist in, this institution does not exist in Europe. As I said, UK also long time ago decided to abandon this really strange form of checks and balances on the prosecutor. But this is another form how we can perceive the independence of the prosecutor to be controlled in a certain way. In this case, this is the decision of the citizens, the decision of the peers of the person that is to be charged with a crime. But when we are talking about this vertical dependency of the prosecutor, and I would really like to have some time to discuss it with you, how far we would agree for the bosses to decide on what the prosecutor should be doing. Do we allow the head of the prosecution service in a certain area to set the policy for that area, or we allow prosecutors from that office to decide by themselves whether the case is worth pushing forward or not? It is, of course, more important in systems that have the the discretionary power of the prosecutor, that they which do not have the principle of legality as in case of Poland. But I still believe that even though we officially have the principle of legality, in many countries there are some forms how we could hide those discontinuations of the cases, of the criminal cases, in other forms of arguments than just by saying that this is not in the interest of justice to push it further. So would it depend on the age of the prosecutor? How long the prosecutor works in the office? Would it depend on the views of the prosecutor? Some prosecutors might be more against the drug addiction for many reasons. Some prosecutors might be more interested in prosecuting hate crime, minors. So there, of course, we would love to believe that everybody are objective and they're the same standards. But again, examples of those countries that give a leeway on discretion to the prosecutor shows that in the offices, let's say in the big cities, when the prosecution service is working, the little drug crimes are under prosecuted because simply there is no time and resources to focus on those crimes. We are looking at big drug dealers and overlooking those who are smaller. And in very small areas, rural areas where drug addiction is not as big as in big cities, the prosecution also perhaps having more time, and police might be looking more deeply into every single use of drugs and possession of drugs and dealing in even not very in minor cases. So there are geographical differences, and they can be justified that in those bigger cities there are more important things to be done than in those smaller cities, especially again in those countries or in those systems where we have discretion of the prosecutor, but also maybe some personal bias and prejudices that we have hard time to accept, both for judges and for prosecutors and for everybody else, are playing a role here. So should it be verified? I would be probably very interested in prosecuting every single hate crime against LGBTQ plus community, because this is according to my beliefs, and I would not prosecute abortion cases if I were a prosecutor. But I'm not sure that all prosecutors in all countries share my view. So is the head of the office responsible for setting the policy within the office, or is the someone from the higher office, or is it the prosecutor general or minister of justice to set the policy, which would limit the independence of the prosecutors? And remember, international standards do not forbid the government to set those policy standards for combating crime of different kind in certain areas. So this general policy can be given, and under some circumstances also some more direct orders, taken into account that they are given in a full transparency, are also accepted. So we are just around noon. And is it okay that I finish right now and we start discussing this topic? Because I'm really interested in the answer that you could give me, because I have to admit, I have never decided for myself 100% where is the line where we should put this vertical form of independence for the prosecutor. And I understand that there might be some circumstances where the prosecutor should be given a second check or even taken the case from under some circumstances. And what do you think? How we should phrase it? And because I also invite you to discuss the relation with the executive and judiciary, but as I said, I do not believe that this is where we position the prosecution service is determinant to how it works in practice, because there are other elements to it. So thank you very much for listening to me. And once again, I'm very thankful for inviting me to this conference.